Welcome back to the deep dive. For any company, there's this critical moment, the point where it goes from an internal project to something bigger, inviting the public in. And that moment isn't just about getting cash.
No, it's about entering a pact. It's a social contract with investors, and that contract is written in the very, very strict language of corporate law.
And that's exactly where we're going today. We are diving headfirst into the engine room of how companies raise capital. Chapter 3, Prospectus and Allotment of Securities. Specifically, we're covering sections 23 all the way through 42.
Right. And our mission today isn't just to list off rules. We want to get into the why. Why is a prospectus only valid for 90 days? Why is private funding capped at 200 people? It's all about deep conceptual understanding using the statutory text and the rules, like the Companies Prospectus and Allotment of Securities Rules 2014, to see the full picture.
So let's start with the roadmap. Section 23 lays it all out. It draws a very clear line in the sand between public and private companies and how they can raise funds.
It does. For a public company, you've got two main highways. The first is the big one, the one everyone thinks of, the public offer.
The IPO, the FPO, that whole world.
Exactly. And that's governed by the whole suite of sections from 23 up to 41, with the prospectus at its heart.
But there's another route for them, right? A more targeted one.
Yep. The private placement under Section 42, this is when they don't want to go to the whole market, just a select, hand-picked group of investors.
Okay, so that's for public companies. What about private ones? They're much more boxed in.
Far more. A public offer is completely off the table for them. They're stuck with three options: a rights issue to their existing shareholders, a bonus issue, or, just like public companies, they can use that very same, very regulated private placement route under Section 42.
Got it. So that's the framework. Let's start with the most basic question of all.
What are we even selling?
Exactly. What is a security?
Well, the problem the law always faces is companies getting creative to avoid rules. I mean, if you define a security as just stock, tomorrow a company will invent something called a revenue participation unit that does the exact same thing but isn't technically stock.
So they'd sidestep the entire regulatory framework.
Precisely. To stop that, the definition has to be incredibly broad. It pulls its definition from the Securities Contracts Regulation Act 1956 to make sure it's a huge, all-encompassing net.
Okay, so what's in that net? Obviously the basics like shares, scripts, stocks.
Right, and all the debt instruments you'd expect. Bonds, debentures, debenture stock. But then it gets modern. It has to include derivatives, units from collective investment schemes, things like mutual fund schemes.
And I see it even includes something really specific from the banking world. A security receipt under the Sarfazi Act.
Yes, that's a perfect example of the law evolving. After the financial crisis, these instruments became more common, so the definition had to expand to include them. Basically, if it's a tradable financial interest in a company, it's probably a security.
But the exceptions are just as important for drawing the line. There's one really specific thing that's carved out.
The unit-linked insurance policy, or ULIP. The law is very clear. Any instrument that mixes a life insurance risk benefit with an investment component is not a security for these purposes.
Why that specific carve-out?
It's about regulatory jurisdiction. ULIPs are the territory of the Insurance Regulatory and Development Authority, the IRDA. The law doesn't want two different regulators fighting over the same product. So SEBI and the Companies Act step aside.
So if you're in an exam and you see unit-linked insurance policy, the answer is no, it's not a security here, but a security receipt from National Asset Reconstruction Ltd.
That's a definite yes. It's a perfect contrast to test your understanding of that boundary.
All right, so we know what a security is. Now, who's the watchdog?
Yeah.
You've got the central government, the registrar of companies, SEDI. Section 24 has to untangle that, doesn't it?
It does, and it's a really clever split. It divides the authority based on the function, not just the regulator's name. It's about what's being done.
So who handles the stuff related to the open market? The trading, the issuing?
That is firmly SEBI's domain. SEBI administers the rules for issue and transfer of securities and also non-payment of dividend. But, and this is a huge, but only for listed companies or those planning to list.
Okay, so if you're on the stock exchange, SEBI is your go-to for market-facing actions. What about everything else?
Everything else falls under the government registrar's domain. And this is for all companies, listed or not. This is the foundational corporate stuff. We're talking about the actual prospectus filing, the return of allotment, and big internal capital changes like the redemption of preference shares.
That's a critical distinction. Let's do a quick test case. A big listed company wants to redeem its preference shares. Is that SEBI's business?
Not at all. That's a fundamental capital restructuring and all other matter. So the power stays with the central government or the registrar. Just because the company is listed doesn't mean SEBI oversees everything it does. It's only those specific market-facing actions. That clarity is so important for compliance.
Absolutely. Okay, let's move on to the star of the show. The document at the heart of it all. The prospectus.
If Section 24 is about who is watching, the prospectus is what they are watching. The entire point is to fix the information imbalance between the company and the potential investor.
It's the anchor document. So Section 270 gives us the definition. It says it's any document called a prospectus, but then it specifically includes a few other things to broaden that net again.
Right. The definition explicitly pulls in the red herring prospectus from Section 32 and the shelf prospectus from Section 31. But then it adds the massive catch-all phrase.
Any notice, circular, advertisement, or other document inviting offers from the public.
And that's the phrase that has generated so much case law. What on earth is the public?
Yeah, if I'm starting a company and I email my 20 cousins asking if they want to buy shares, is that an offer to the public? Have I just accidentally issued a prospectus?
That's the million-dollar question. And the law says public includes any section of the public. It doesn't have to be everyone. The real test is whether the offer is open to people beyond your personal circle, whether there's some element of publicity.
Let's look at the classic cases. First, South of England Natural Gas.
A fascinating one. The company printed thousands of documents. They stamped for private circulation only, all over them, and they only sent them to a specific group members of various gas companies. They thought they were being clever.
But the court said no.
The court said no. The recipients, even though they were a select group, were still the public. The company didn't know these people personally. The sheer scale and impersonal nature of the distribution made it a public offer, and the document a prospectus.
So that's one end of the spectrum. Now let's contrast it with Nash v. Lend.
This case draws the line perfectly. Here, a document marked strictly private and confidential was sent to one person. A single, private, targeted communication.
And the court's finding.
The court found it was not an issue to the public. The judge said a public offer has to be open to anyone who brings his money. Since this was a one-to-one private conversation, it wasn't a prospectus. So you have this scale. Thousands of impersonal mailings is public. One private letter is not.
That clarity is incredibly helpful. All right, so what if a company tries to get around this by using an intermediary, a kind of liability shield?
Now you're talking about the deemed prospectus under Section 25. This section exists purely to close that loophole, what you called the middleman maneuver.
So what's the scheme they were trying to pull?
Simple. The company would sell its entire block of shares to, say, an investment bank at a discount. The company would say, we didn't sell to the public, we sold to one institution. Then the bank would immediately turn around and sell those shares to the public using its own offer document.
And the original company would try to claim its hands were clean of any prospectus liability.
Precisely. And Section 25 says, nope, not going to work. That document from the bank is deemed to be a prospectus from the original company if two conditions are met.
What are the triggers?
The first trigger is timing. If the offer to the public happens within 6 months of the company's initial allotment to the intermediary, that's a huge red flag.
6 months. Okay, what's the second trigger?
It's about the money. If the full consideration has not been received by the company from the intermediary when the public offer happens, if the bank hasn't paid the company in full yet, it's pretty clear they're acting as an agent, not a principal.
So if either of those tripwires is hit, the bank's document becomes the company's problem.
It becomes the company's prospectus. And because of that, Section 25(3) even adds extra disclosure requirements. The deemed prospectus has to clearly state the net amount of consideration the company is actually getting. It forces them to be transparent about the intermediary's cut.
Brilliant. Okay, let's talk about the specialized prospectuses designed for efficiency. Starting with the shelf prospectus in Section 31, what problem is this solving?
Repetition. Imagine you're a big bank that needs to issue bonds every few months. Filing a full 100-page prospectus each time is a massive, costly, and redundant exercise.
So the shelf prospectus is like a master document.
Exactly. You file it once and it stays valid, or on the shelf, for all subsequent issues of that same class of security.
And how long can it stay on the shelf? What's its validity?
Up to 1 year from the date of the first offer.
But a lot can change in a year. The company's financials, its projects. How does the law account for that?
With a sidecar document. For every subsequent offer off that shelf, the company must file an information memorandum, or IM. It's an update.
And what's in the IM, and when does it need to be filed?
It has to be filed with the registrar at least 1 month before the issue opens, and it must contain all the new material facts, new debts taken on, major changes in financial position, stuff like that.
This is where the investor protection really kicks in. What if I've already applied for the next batch of bonds, and then the IM comes out and I see something I don't like?
You have an out. The law says if an applicant wants to withdraw after seeing the new information in the IM, the company shall refund all monies to them within 15 days. It's a non-negotiable right to back out.
So legally, the shelf prospectus plus the new IM together are considered the full prospectus for that specific offer.
That's the legal reality. And here's a quick mnemonic to remember that filing timeline. Just think. Shelf to IM is 1 month. SIM 1 month.
I like that. SIM 1 month. Okay, next up, the red herring prospectus, or RHP, under Section 32. This is crucial for IPOs, isn't it?
It's indispensable. It's all about price discovery. An RHP is, by definition, a prospectus that is incomplete. It does not include the final price or the exact quantum of securities being offered.
It allows the company to go to the market and say, how much would you be willing to pay for our shares?
Yeah.
And then set the price based on that feedback.
That's the book building process in a nutshell. But, and this is so important, just because it's incomplete doesn't mean it's liability free.
So you can't put misleading information in an RHP and then just fix it in the final version.
Not a chance. The RHP carries the same obligations and liabilities as a final prospectus. A lie in the RHP is still a lie, and you'll be held accountable. Once the offer closes and the price is set, a final, complete prospectus must be filed with the registrar and SEBI.
Got it. And the last one in this family is the abridged prospectus under Section 33. This one's really about saving paper, right?
And costs. It's basically a summary, a memorandum with just the salient features of a prospectus. The general rule is simple. Every single application form you send out must have an abridged prospectus attached.
But there are exceptions. There are times when you don't need one.
3 key exceptions. And we can use another mnemonic for this. To remember when an abridged prospectus is not needed, just think UME.
UME. Okay, break it down for us.
U is for an underwriting agreement. M is when the shares are not offered to the market or the public. And E is for offers made only to existing members or debenture holders. In those cases, the investors are either sophisticated or they already know the company, so the summary isn't deemed necessary.
That's a great way to remember it. UME. Okay, let's get into the nitty-gritty of what a prospectus must contain, according to Section 26.
Right. This section is the compliance checklist. It has to be dated, it has to be signed, and it must contain a declaration that you've complied with everything. The Companies Act, the SCRA, the SEBI Act, all of it. It's a legal oath, really.
And the signing requirement in Section 26(4) is really strict about who has to put their name on the line.
It is. It has to be signed by every person named as a director or a proposed director. There's no hiding. The law wants to ensure personal accountability at the highest level. You can't have a director later claim they didn't see or approve the document.
What about expert statements? Reports from engineers, valuers, accountants. Section 26(5) puts up some serious guardrails there.
It has to. Investors rely heavily on those third-party opinions. So the law demands absolute independence. An expert statement is prohibited if they fail what I call the INW test. Yes. The expert cannot be interested in the company's formation or management. They must have given their written consent, so no consent is a no-go, and they can't have withdrawn that consent before filing, INW. Interested, no consent, or withdrawn consent. Any of those, and their statement is out.
That makes perfect sense. Now, we touched on this earlier, but Section 26(8) gives the prospectus an expiry date.
It does. It's valid for only 90 days from the date it's delivered to the registrar, any later than that, and the financial data is considered too old. The company has to go back and prepare a new, updated prospectus.
And what if a company breaks any of these Section 26 rules?
Section 26(9) lays out the penalty. A fine between $50,000 and $30,000 on both the company and every person knowingly involved. Compliance is not optional.
So once the money is raised, it has to be used for the reasons stated in the prospectus. That's the doctrine of ultra-buyers. But what if the company needs to pivot? That's where Section 27 comes in.
Yes, and this is a huge deal. If you told investors you were building a factory and now you want to develop software, you are fundamentally changing the deal. You can't do that unilaterally.
So what's the process?
It requires a special resolution from the shareholders. You have to get their explicit permission. And Rule 7 says you have to advertise this proposed change in newspapers explaining why you're doing it.
And what about the investors who say, this isn't what I signed up for?
The law gives them the ultimate protection, an exit offer. The promoters or controlling shareholders are legally required to offer to buy out any dissenting shareholders at a fair price determined by SEBI. If you change the game, you have to let the unhappy players cash out.
Now, there's one thing the company absolutely, positively cannot do with the money raised, no matter what.
This is a hard and fast rule. The funds raised via prospectus cannot be used to buy, trade, or deal in the equity shares of any other listed company. The public gave you money for your business, not to play the stock market.
That's a very important line in the sand. Okay, let's briefly touch on an offer for sale under Section 28. This is when an existing shareholder sells their stake, not the company raising new capital.
Right. But because it's still an offer to the public, the disclosure document is treated as a prospectus issued by the company. All the same rules and liabilities apply.
And since the company's doing all the compliance work, the selling shareholder has to pay for it, right?
Section 28(3) is clear. The selling members must reimburse the company for all expenses incurred. It's their sale, so it's their bill.
And because the company itself isn't raising money for its projects, a couple of the usual allotment rules are waived.
Correct. The requirements for minimum subscription and minimum application value don't apply. The company's viability isn't at stake, so those rules are irrelevant here.
Got it. Now, a couple of quick modernizing rules. Section 29 on dematerialization.
It's a simple, modern rule. Any company making a public offer must issue its securities in dematerialized form only. No more paper certificates. It's all electronic, which is more efficient and secure. This has also been extended to certain large unlisted companies as well.
And Section 30 on advertisements. If you advertise the offer, what core info must be included?
It's like a mini summary of the company's legal DNA from the memorandum. You can remember it with the mnemonic, only legal signatures need cash.
Okay, let's hear it.
Objects, liability of members, names of the signatories, number of shares they subscribe to, and the capital structure. It gives a potential investor the bare-bones legal facts right in the ad.
Perfect. Okay, we've gone through the procedure. Now let's get to the integrity of the liability. The standard of disclosure is uberrime fides, of most good faith. Why is that standard so high here?
Because of the massive information asymmetry, the directors know everything, the investor knows only what's in the prospectus. That complete reliance means the company has a duty to be completely honest and transparent. You can't hide the ugly parts.
A breach of that duty is a misstatement. And Section 34 defines this broadly. It's not just an outright lie. It's anything misleading in the form and context in which it appears.
An omission can be just as misleading as a false statement. Sometimes what you don't say is the biggest lie of all.
Let's use the classic cases to illustrate this. Start with Henderson v. Lacan. This is a pretty direct lie, wasn't it?
It was. The prospectus claimed directors and their friends had subscribed a large portion of the capital. It was meant to show a vote of confidence. The reality, they'd only bought 10 shares each. It was a factually misleading statement designed to create a false impression.
Okay, what about hiding the truth by telling a technically true but misleading story? The case of Rex v. Colsant.
This one is a masterclass in deception. The company truthfully stated it had paid dividends every year for a decade. Sounds great, right?
Sounds very stable.
But they left out the crucial context. For the last few years, the company was actually losing a lot of money. The only way they could pay those dividends was by dipping into old reserves. So they were presenting an image of profitability while they were actually bleeding cash. The court said that was a gross misrepresentation.
And finally, the danger of just being ambiguous. The Smith v. Chadwick case.
Here, the prospectus said the present value of turnover is £1 million. The statement was technically true if you interpreted turnover to mean the factory's maximum possible production capacity, but it was completely false if you interpreted it as the company's actual current sales.
And the directors knew it would be interpreted the second way.
Of course. They used ambiguity as a weapon. The court's lesson is clear. If a statement can be read in a misleading way, it's your job as a director to clarify it. If you don't, it's a misstatement.
So, when a misstatement happens, what are the remedies? There are two big tracks, criminal and civil.
Let's start with the big one, criminal liability under Section 34. The crime is simply issuing a prospectus with an untrue or misleading statement.
And who is on the hook?
Every person who authorized the issue. And the punishment is severe. It's under Section 447 for fraud. But the key thing to understand here is that this is strict liability.
Wait, explain that. You can be held criminally liable even if nobody actually lost money because of the lie.
Absolutely. The crime is the act of polluting the market with false information. The damage is to the integrity of the system itself. Whether a specific investor made or lost money is irrelevant to the criminal charge. The only defense is to prove you had reasonable grounds to believe the statement was true.
Wow. Okay, so that's the punishment track. What about the compensation track for the investor who did lose money?
That's civil liability under Section 35. This is all about making the investor whole again. It's triggered when a subscriber suffers loss or damage because they relied on the misleading prospectus.
And who has to pay up?
The net is wide. We can use the mnemonic DPPAE to remember the liable parties.
Deep.
Directors, promoters, proposed directors, anyone who authorized the issue, and the expert whose statement was included. They're all on the hook to pay compensation.
But they have defenses, don't they? Section 35(2) gives them an out.
They do. For a director, a key defense is proving they withdrew their consent and gave reasonable public notice as soon as they found out a prospectus was being issued with their name on it without their permission.
And what about relying on an expert?
That's another major defense. You can argue that you reasonably believed the expert was competent and that their statement was true and that the expert hadn't withdrawn their consent. It's about showing you do your due diligence.
Okay, so that's criminal and civil liability. Let's quickly talk about some of the other tools for investor protection. Fraudulent inducement under Section 36.
This broadens the net. It makes it a crime under Section 447 to knowingly or recklessly make any false statement, not just in a prospectus, but anywhere, to induce someone to invest.
In Section 37, brings in the idea of a class action suit.
Which is vital, because often the financial harm is spread across thousands of small investors. It's not practical for each one to sue. A class action allows a group of affected people to sue together, which gives them the power to take on a large corporation.
And what about the old common law remedy of rescission? Just voiding the contract.
It's powerful but limited. It's only available to the original subscriber who bought the shares directly from the company. If you buy the shares a month later on the stock market, you can't use rescission.
And that's the lesson from the famous Peake v. Gurney case, isn't it?
The definitive lesson. The court said the prospectus's job is done once the first batch of shares are allotted. Its power doesn't extend to the secondary market. If you buy on the market, you can't sue based on the original prospectus.
Okay, one last piece of criminal liability. Punishment for personation under Section 38. This is about applying for shares using fake names.
Right. And again, the penalty is under Section 447. But the court can also order disgorgement of any gain. They can seize the profits made from the fraud and put that money into the Investor Education and Protection Fund.
And this all comes back to Section 447, the big fraud provision. It defines fraud so broadly, doesn't it?
Incredibly broadly. It's any act, omission, concealment, or abuse of position done with the intent to deceive. And critically, it doesn't matter if there was a wrongful gain or a wrongful loss.
So just to be crystal clear, if a director authorizes a fraudulent prospectus, but by some fluke the investor doesn't lose any money, the director is still guilty of fraud under Section 447.
100%. The crime is the fraudulent act itself. The outcome is irrelevant. The penalties are huge, especially if public interest is involved, with mandatory jail time and fines that can be up to 3 times the amount of the fraud.
A serious deterrent. Okay, let's shift from liability to the mechanics of the allotment itself. Section 39 and the concept of minimum subscription. Why does this rule exist?
It's a viability check. Imagine a company says it needs 10 crores to build a factory. If they only raise 1 crore, they can't build the factory. Letting them take that euro crore and start business would be setting them up to fail and defrauding the investors.
So the minimum subscription is the funding floor they have to hit to proceed.
Exactly. And under SEBI rules, that floor is usually high, 90% of the entire issue. If you don't hit that 90% target, you can't allot a single share.
Section 39(2) also sets a minimum for the application money itself.
It does. The Act says it must be at least 5% of the nominal value, but in practice, SEBI's rules are stricter, often requiring at least 25% of the issue price up front.
And what if the company fails to get that 90% subscription within 30 days?
The offer fails, and they have to return all the application money they collected.
How quickly do they have to return it?
Rule 11 gives them 15 days from the closure of the issue to send the refunds. If they're late, the directors become personally liable to repay the money with a punishing interest rate of 15% per annum.
So in that Raksha detective example, where they only got 80% but started allotting shares anyway, that whole allotment is illegal.
Completely illegal and voidable. The subscriber, Rashmi, can demand her money back immediately, and the directors are on the hook for that 15% interest penalty for their failure to refund in time.
Okay, once you've got minimum subscription, you need to get listed. Section 40.
A mandatory step for a public offer. Before you even issue the prospectus, you must have applied to at least one stock exchange and received permission to list. And you have to name those exchanges in the prospectus.
What if you apply to 3 and only get permission from 2?
That's a fail. You need permission from all the exchanges you applied to. If you proceed with the allotment anyway, you're facing big fines under Section 44.
And while you're waiting for that permission, what happens to the investor's money?
It has to be kept in a separate bank account in a scheduled bank. It's quarantined. You can only use it for 2 things: adjusting against the allotment if you succeed, or refunding it if you fail.
And you can't trick investors into waiving these rights.
Section 44 makes any such condition completely void. Investor protection here is absolute.
Let's talk about underwriting commission in Section 46. Companies pay this to guarantee the issue succeeds. What are the rules?
First, it must be authorized in the company's Articles of Association. Second, it can be paid out of the issue proceeds or the company's profits.
And there are caps on the rates, right? The whichever is less rule.
Yes. For shares, it's a maximum of 5% of the issue price, or the rate in the articles, whichever is less. For debentures, it's lower, 2.5% of the issue price, or the rate in the articles, whichever is less.
So if the articles say 3% commission on shares, the board can't decide to pay 5%, even though that's the statutory limit.
They cannot. They are bound by the lower of the two, which is the 3% in their own articles.
Okay, let's wrap up with 2 specialized ways to raise capital. First, Global Depository Receipts, or GDRs, in Section 41. Why do these exist?
To give Indian companies easy access to foreign capital markets. It's much simpler than trying to list your actual shares on a dozen different foreign exchanges. It requires a special resolution from shareholders.
Could you walk us through the mechanics? It seems complicated.
It sounds it, but the flow is logical. The Indian company issues shares, which are held by a domestic custodian here in India. An overseas depository bank then issues GDRs abroad, which are backed by those shares. So foreign investors trade the GDRs, not the underlying shares.
And how do they vote?
They don't, not directly. The overseas depository votes on their behalf, based on the deposit agreement. The only way a GDR holder gets a direct vote is if they convert their GDRs back into the underlying Indian shares.
Makes sense. Finally, the big one for non-public fundraising. Private placement under Section 42.
A critical tool for both public and private companies to raise capital from a select group of persons without going through the whole public offer process.
And the key restriction here is the number. What's the cap?
It's capped at no more than 200 persons in a single financial year.
But not everyone counts towards that 200, do they?
Correct. There are 2 major exclusions, which you can remember as QE for quality exclusion.
GD.
Q stands for qualified institutional buyers, the big, sophisticated investors who don't need the same protections. And E is for employees being offered shares under an ESOS plan.
And importantly, that 200 limit isn't a total company limit for the year, is it?
No, and this is a crucial detail. It's reckoned individually for each kind of security. So you could, in theory, offer equity to 200 people and debentures to a completely different group of 200 people in the same year.
Now let's talk about the most complex part of Section 42, the so-called Chinese wall rule about overlapping offers. What is the law trying to stop here?
It's trying to stop companies from stringing together a series of private placements that, when combined, are actually a disguised public offer to more than 200 people.
So how does the rule work?
It's a hard stop. A company cannot make a new private placement offer if the allotment for any previous offer, even for a totally different type of security, is still pending.
So let's use the PQR Bakers example. They offer equity to 51 people. Before they finish allotting those shares, they start a second offer for debentures to 155 other people. What happens?
Disaster. Because the second offer was launched before the first was completed, they breached the Chinese wall. The consequence is catastrophic. The law deems both offers to be a public offer. And since they didn't follow any of the public offer rules, they're in massive violation of the act.
The timing error basically invalidates the entire fundraising effort.
And triggers enormous penalties. The procedures are strict for a reason. The offer has to be in Form PS4, payment must be via banking channels only, and there's no right of renunciation.
And there's a ticking clock for allotment.
A very tight one. You must allot the securities within 60 days of receiving the application money.
And if you miss that 60-day deadline,
You have a 15-day grace period to refund the money. If you miss that, you have to repay it with interest at 12% per annum from the end of the 60th day. And then you have to file the return of allotment, Form PS3, within 15 days of the allotment.
the penalties for getting any of this wrong are designed to hurt.
They are designed to be a complete deterrent. A fine equal to the amount raised, or 2 crore rupees, whichever is lower, for the promoters and directors. And the company has to refund all the money anyway. It's a lose-lose if you don't follow the rules to the letter.
So after this deep dive, it's clear the law around raising capital is this intricate web of safeguards. We've seen the two main paths, public offer versus private placement, and the absolute demand for uber fide's utmost good faith in disclosure.
Exactly. We've seen the difference between criminal liability in Section 34, which is about punishing fraud against the market, and the civil liability in Section 35, which is about compensating the victim. And we've seen how critical procedural timing is, especially that Section 42 Chinese wall rule.
All these rules, the 90-day prospectus life, the 60-day allotment window, the ban on using IPO money to play the market, they aren't just red tape. They're the very foundation of market confidence, ensuring the promise made to an investor is a promise kept.
And that brings us to a really interesting paradox we touched on. Under Section 27, the law is absolutely terrified of a company using money from a prospectus to go and buy shares in another listed company. It's a total prohibition.
Right. But that very same section is perfectly fine with a company completely changing its own business. It can go from making cars to selling coffee as long as it gets a special resolution and offers an exit to those who don't like the new plan.
So here's the final thought for you to take away. Why is the law so much more rigid and controlling about where a company directs its capital externally into the market than it is about how a company can completely reinvent itself internally? It's a deep question about fiduciary duty, risk, and the core purpose of a corporation. Keep digging.